We're a registered business broking firm. We focus across Australia and facilitate the buying and selling of financial planning books and practices. Today we're talking to Martin Checketts from Mills Oakley Lawyers about some of the legal aspects of buying and selling a financial planning business.
If you co-own a financial planning business with one or more business partners, it's really important to put an agreement in place between you to regulate your relationship ongoing. If you run the business through a company structure, that agreement's called a shareholders agreement. If you run it through a unit trust, it's a unit holders agreement. If you run it through a partnership, it's a partnership agreement, etc. One important clause that you should think about is whether there will be drag-along and tag-along rights in your shareholders agreement. A drag-along right is essentially the right for the majority owner to procure or ensure the sale of the entire business or share capital to a third party. So commonly, if you own, for example, 70 or 80 or 90% of your financial planning business, maybe you've sold down a minority interest to some of your senior employees, it will be important for you to retain control over exit mechanisms. And this drag-along right is a really important part of that. So if a big listed acquirer comes along, for example, and they're looking to acquire your business as part of a roll-up play, it will be important for you as the majority owner to be able to make that happen. And if you don't have a drag-along right, then the minority owners may well be able to block that sale. A tag-along right is really the flip side of a drag-along. The drag-along protects the majority and it allows them to procure the exit of the whole business. The tag-along is the right for the minority shareholder to sell along with the majority shareholder for the same price and terms. So, for example, say if we had a business that was owned by John, who held 80% of the shares, and Fred, who held 20% of the shares, Fred might be concerned if John just goes ahead and sells his shareholding to a third party. That means Fred is now a minority shareholder in a business that he co-owns with somebody else and somebody that perhaps he doesn't know or trust. So from Fred's perspective, it's really important that John selling his 80% should also trigger a right for Fred to ensure that John procures the sale of Fred's 20% at the same time and for the same price and terms.